I just lost it. It just went to the bottom.
I know. Yeah. Now I just need to. All right, Mr. Elliott, if you can unmute yourself, please.
Your Honor. Can you hear me now?
Yes, I can hear you now. Okay. And you're going to keep is Miss Reeves in your office? Like,
She is right across the table from me.
okay. So if such time arises that Miss Reeves testifies, you two will not be in the same room unless you're on the same device. Otherwise, your two devices are going to create a feedback.
What I did is I have muted her, so it'll only
Okay.
pick up on mine.
Okay, good. Okay. All right. Before we get on the record and before we get started, is there going to be any objection to any witnesses or attorney appearing via Zoom before we?
No, as far as I'm not exactly sure. I know he has Miss Reeves, his client, who's the defendant there. What about the other witnesses, if any he intends to call? I don't know who he intends to call.
Mr. Elliott, do you have any additional witnesses you intend to call, and how are they going to appear today?
No, Your Honor, just Miss Reeves.
Well, if that's, I have no objection to Mr. Elliott and Miss Reeves appearing via Zoom.
Okay.
Now, to the court, I have one witness is Mr. Mosley, who's with Austin Bank here. We'd asked him to be sworn in, of course, and we'll let him sit outside if that's all right. And then I have two others that'll be here 9:30 or 10.
Okay.
And I may or may not call them, just kind of depends on how things get over.
Okay. And have you and Mr. Elliott gotten together and agreed on any stipulations as to any exhibits, just so that we can make efficient use of our time?
Yes, we have. Well, we've exchanged. I don't know if he's seen Mike. I didn't know he was doing this. I have a book for him. His staff came over and got it, and then
Okay.
she just handed me his.
Sure, absolutely.
I'm looking at his. Paul, can you hear me? I assume.
Yeah, I can hear you, and I've got yours in front of me.
Oh, good. All right. So you just want to go through?
Yeah, let's just go through and we'll be off the record. And then if we get an agreement, then we'll just go when we get on the record. I'll let y'all formally stipulate to them.
Paul's exhibit number 1 is, I have no objection to. It is the same as my exhibit number 1. We're on the same page there. So I would assume that we could.
And however y'all want to do it, if you want to reference them as D1, P2, however you want to do that, I'm just going to let y'all I'm not going to make any notes right now. I'm just going to let y'all formally stipulate to it once we get on the record.
That's fine.
Do y'all want to spend some time working on this before we get going? Okay.
I think there's only probably the photographs are really.
Okay.
So,
Judge, I mean, everything that I see with Mr. Alexander, these are things that he's produced, and we've had 2 years to look at them. I think, like I said, most of his are towards the loan itself, and most of mine are probably photographs taken either with or by Ms. Reeves that we produced a long time ago.
Right.
They've been topics of depositions. They've been topics of production, interrogatories.
Your exhibit number 2 is I guess a copy of the floor plan. I don't have any objection to that, except what's the writing in the middle of it? Whose writing is that?
I think that is Miss Reeves' writing. It was just a notation on the plan that I think everybody was working off of. I can't even read what it is. It's something about the wall.
Okay, I don't.
And it's not anything in issue in the suit.
I can't tell what it says, but I have no objection to the picture of the floor plan. I can't tell what that says, and if Ms. Reeves wrote it, either way, I would object to the writing of it. I don't know what it even says. It says something about
A wall. I think it's a measurement, maybe the height. I'm not sure, but it's not anything that we will use in reference.
Well, other than objection to the writing, I have no problem with exhibit number 2. And then when you get to your defendant's exhibit number 3, Your Honor, is this, well, he's got actually a bunch of pit photos. So these photos were taken either by Miss Reeves or on her behalf by someone.
Yeah, she was present. She either took them or were there when they got taken. She believes most of these are all hers.
For instance, the first one, which is exhibit number 3, her deposition testimony clearly indicated that she did that writing on there. And I do object to the writing. I don't think it's proper.
Well, let's do this then. Yeah, I want to know what y'all agree to. And then whatever it's not agreed, then I know that that's going to be offered, and then we'll get the objections on the record, because we're not on the record right now. So
Judge, and what I would
these are the
represent,
ones I agree to. These are the ones.
So that means you take the number 24, which is a letter dated April 20, no problem. I have the same exhibit. I can tell you which one it is if you want me to, but he's already said he doesn't object to it. So,
How many exhibits do you have, Mr. Alexander?
I had 13.
You have 13. And Mr. Elliott, you have 28.
yes, Your Honor. And 50% of this is just a deposition.
The deposition.
Yes.
50% of the notebook is a deposition. That's his exhibit 28. All right. So Mr. Alexander, or so Mr. Elliott, you agree, you stipulate to all of Mr. Alexander's exhibits P1 through P13.
Judge, I see nothing to object to, Your Honor.
Okay. All right. And so what is, and so Mr. Alexander, you have agreed, you've stipulated to 1, and 2.
Two with the sole issue of the handwriting on it. 2 is that floor plan.
All right. So you're going to, then we went to 24.
Skipped over 3. Yes, 24, which was okay. It's the same one I have. I have this same. Tell you that. April 21st letter is the same as 7, last 7.
Okay. So you agree to 24. That brings us to 25.
25 is the same as my 12, so I have no objection.
25.
26 is an opinion from an expert that you have had ruled twice is not admissible. You know, we had a couple of we had a hearing initially, and then we kind of rehashed it again, and you ruled that this expert could not testify at trial because he had not been designated timely. So his opinion should not come into this case.
And Judge, we also.
Hang on, so you don't stipulate to 26?
No,
All
sir.
right, let's move on to 27. We'll save all the objections to when the exhibits are offered.
Absolutely.
Sorry.
Number 27 is his attorney's fee. I don't have an objection to that to the extent that they're, I mean, I don't have an objection technically to it.
Okay, so you'll stipulate to 27 and then 28 is the
I'm not
deposition.
attorney's fee, but I'm not.
Right, to the admission. I'm just looking to the admission of the exhibit into
And
evidence.
then number 28, I think is his last one, right? And that's just a copy of Mr. Mewbourn's deposition.
Yes. So you stipulate to that. So there's an agreement as to P 1 through 13, and there's an agreement as to D 1 to 24, 25, 27, 28. And we'll make a record on all of this. And then that will leave Mr. Elliott to offer, if he so chooses, the exhibits that are not stipulated to. I think that'll save us a little bit of time. We'll probably make our record cleaner as well. So I'll just ask for that. I'll just restate what the stipulation is and have each one of you make an announcement on the record about that. All right, and so you have one, I'm assuming your client, 1, 2, so 2 to possibly 5, 4.
Well, 5 with me, sorry. It's attorney fees.
And Mr. Elliott, you just have 1.
Mhm.
And him is this.
Okay. Are we gonna play any videos or anything of that nature? No walking inspection video, anything like that? Okay.
No, Your Honor.
All right, and no one else is appearing via Zoom other than you and Miss Reeves. Okay, that looks good. Anything else that we need to take up before we get on the record? How long do you anticipate for your case? Obviously, I know you can't control cross, but
I can't imagine a couple hours.
okay, for your side.
This is a quantum merit issue, so it's you know, they want to get into the weeds about a lot of stuff, but our case is contract.
Okay. All right, and Mr. Elliott, you've kind of said the same thing, right? About you anticipate about half a day for.
Yeah, Judge, I'm looking at probably 2.5.
Okay. Okay, all right, well, let's go ahead and you ready to go on the record, Ms. Grisham? All right, court calls call number 17-00147. And this is styled Paul Mewbourn versus Karen Reeves. It's also styled defendant Austin Bank, Texas. My understanding is that Austin Bank was an intervener in the case who has been dismissed out by the plaintiff's motion in the court's order. Is that correct, Mr. Alexander?
Correct, Your Honor.
And I'll go ahead and ask for appearances for the record, Mr. Alexander.
Your Honor, George Ivan Alexander, appearing on behalf of Paul Mewbourn, the plaintiff, and I guess technically would be considered the counter defendant as well, in this case. And we are ready for trial.
Thank you, sir. Mr. Elliott?
Yes, Your Honor, Paul Elliott, on behalf of Karen Reeves, the respondent or the defendant in this matter, and also the counter petitioner.
All right, the record will reflect that present in the courtroom for today's trial is Mr. Alexander, his client, and a couple of witnesses, and appearing via Zoom is Mr. Elliott, his client. And Mr. Alexander, is there any objection to Mr. Elliott or Ms. Reeves appearing via Zoom today?
No, Your Honor.
And let me ask this. I believe there was a jury request in this case, and I don't believe I've seen a formal filing withdrawing that request. Is there a request? Obviously, you're not insisting on a jury be impaneled for this case. So, but on the record, you're withdrawing your request for a jury trial in this case. Is that right?
Yes, Your Honor, I believe 2 trial settings ago, all parties agreed to waive. I think we did it on the record. So.
Yeah, there was a joint motion to remove it off of the jury docket and move it onto the docket of the bench.
Okay.
To answer your question directly, yes, we waived.
Okay, good. All right. And Mr. Alexander, if you'll have your witnesses go ahead and stand up, those that are going to testify today. Dwayne Davidson? Yes, sir. With Davidson? Yes, sir. And representative from the bank? Is that Mosely? Eley. Okay. Gentlemen, if each one of you will stand up, raise your right hand. Do each of you swear that the testimony you give to the court today, this matter will be the truth, the whole truth, and nothing but the truth, so help you God? Okay, you may put your hands down. All right, I have sworn you in, and you are under oath, and the rule of sequestration has been imposed by Mr. Alexander. What that means for you is that you are not to discuss this case with anyone else except the attorneys in this case. Do not discuss the case with each other. Do not discuss the case with anyone except those attorneys. Your failure to abide by this order could result in your testimony being precluded before the trial today. Do you understand that? Could also, court could hold you in contempt, sanction you, place you in jail, fine you. So it's very important that you follow that rule. Okay, so what we're going to do is have you step outside at this time, and you'll be called in at the appropriate time for your testimony. Any questions about that? And so you're free. Who's going to be your first witness? Either one of these gentlemen? Okay, so it may take some time for Mr. Mewbourn. So you're free to kind of mill about the courthouse. If you need to go outside, make phone calls, you don't have to just sit out there on those benches. Just be reasonably close and be available for Mr. Alexander. I'm assuming that you have each one of their cell phone numbers. And if we could have each one of you gentlemen come up, and we'll have you give the bailiff here your cell phone numbers. That way, if you do need to step out or you run over to the store or something and you're needed, we can call you.
There's one more, not here yet, but